If you are over 50 and you have a will sitting in a drawer somewhere, or maybe you just paid a lawyer to put one together, I need you to listen to me very carefully right now, because there are four things about that will that could devastate your family, and most lawyers will never tell you about them. Not because they are bad people, not because they are trying to cheat you, but because you didn't ask the right questions, and they didn't go out of their way to volunteer the answers. I know this because I lived it. My name is Harold. I'm 63 years old. I'm a retired general contractor from Scranton, Pennsylvania. I built houses for 38 years. I am not a lawyer. I am not a financial advisor. I'm just a guy who watched his own family get torn apart because nobody had a plan. And after that happened, I made it my business to understand how all of this works so that it would never happen to my family again. My father's name was Frank. Good man. Hard-working man. Worked with his hands his whole life, just like I did. He was the kind of guy who paid every bill on time, never owed anybody a dime, kept his house clean and his lawn mowed and his truck running. He did everything right, or at least everything he thought was right. But he never made a will. He never set up a trust. He never signed a power of attorney. He never sat his kids down and told us what he wanted to happen when he was gone. He just figured we'd work it out, that we loved each other enough to figure it out. He died in 2016 at 81 years old, and within 6 months his family was destroyed. The house I grew up in, the house my father built with his own hands, got tied up in probate court for 2 years. 2 years. My sister Diane and I couldn't agree on anything. Not because we're bad people. We're not bad people. But when there's no plan, when there's no document that says this is what Dad wanted, every decision becomes a fight. Every conversation becomes an accusation. She thought I was trying to take more than my share. I thought she was being unreasonable. And there was a bank account, $14,000, that somehow became the thing that ended our relationship. $14,000. That is what it cost me my sister. We haven't spoken since. And our mother Ruth, who is 84 now and living in assisted living, she nearly lost her home because nobody had set up a trust to protect it from nursing home costs. We got it done eventually, but almost too late. If we had started 5 years earlier, Mom wouldn't have lost a dime. So I learned. I read everything I could find. I sat in on free seminars at the library. I talked to elder law attorneys. I asked every question I could think of. And then I asked the ones I couldn't think of. And what I found out is that even the people who do the responsible thing, even the people who go to a lawyer and get a will, a lot of them are making mistakes that are going to cost their families thousands of dollars and years of heartache. And nobody is telling them. So I'm going to tell you 4 things, 4 mistakes. And I need you to pay attention because this is the stuff I wish someone had told my dad. The first one is the big one, and it's the one that surprises everybody. Your will does not avoid probate. I'm going to say that again because most people don't believe it the first time. A will does not avoid probate. Most people think that if they have a will, their family won't have to deal with probate court. That is flat out wrong. A will is an instruction sheet for the probate court. It tells the judge who gets what. But the judge still has to be involved. The court still has to validate the document. Your family still has to hire an attorney, file paperwork, pay fees, and wait. Months, sometimes years. When my dad died without a will, we were in probate for 2 years. But here's what I found out later that made me sick to my stomach. Even if he had a will, we still would have gone through probate. Maybe faster, maybe a year instead of 2. But we still would have been sitting in that courthouse. We still would have been paying those lawyers. The only thing that actually avoids probate entirely is a properly funded revocable living trust. In plain English, that means the trust owns your assets while you're still alive. When you pass, there's no court involved. Your trustee distributes everything according to your instructions. No judge, no filing fees, no waiting. Now, will a lawyer tell you this? Some will. A good elder law attorney absolutely will. But a lot of general practice lawyers, you walk in and say, "I need a will," and they draft you a will. They collect their fee, they shake your hand, and they never mention the word trust. Not because they're dishonest, because you asked for a will, and that's what they gave you. This is the gap I'm talking about. The gap between what you think you need and what you actually need. And that gap is where families like mine get destroyed. When Linda and I finally sat down with an elder law attorney, Linda is my wife, 37 years now, the first thing he said was, "Forget the will for now. Let's talk about a trust." And I remember sitting there thinking, why didn't anyone tell us this 10 years ago? If you're over 50 and you own a home, if you have any real assets at all, ask your lawyer one question. What happens to this will when I die? Does my family still go to court? And if the answer is yes, you need to have a different conversation. The second thing is one that nobody thinks about until it's too late, and it has ruined more families than I can count. Your beneficiary designations override your will. Let me tell you what that means in plain English. When you set up your 401k, your IRA, your life insurance policy, your bank accounts that have a payable on death designation, you filled out a little form. And on that form you wrote a name, the person who gets that money when you die. Now here's the thing. Whatever name is on that form, that's who gets the money, period. It does not matter what your will says. It does not matter what your trust says. It does not matter what you told your wife over dinner last Thursday. That little form, that beneficiary designation, that is the final word. And most people filled it out 20 or 30 years ago and have never looked at it since. I had a buddy from my contracting days, good man. His name was Gary. Gary got divorced at 52, remarried at 55. Wonderful woman. She treated his kids like her own. Gary was responsible. He went to a lawyer, updated his will, left everything to his new wife and his 2 sons from his first marriage. He felt good about it. He thought he was covered. But Gary never updated the beneficiary on his 401k. And guess whose name was still on it? His ex-wife. When Gary died at 61 from a heart attack, his ex-wife received his entire retirement account, $214,000. And there was nothing, absolutely nothing his family could do about it. The will didn't matter. The beneficiary form was the only thing that mattered. Now, did Gary's lawyer tell him to go update his beneficiary designations? Maybe. Maybe it came up in passing. But Gary didn't hear it. Or he heard it and thought he'd get around to it later. And that one piece of paper that he filled out in 1989 when he first got hired at his company, that one form, that's what decided where his life savings went. Not his will, not his wishes, a form he forgot about. I need you to do something this week, not next month, not when you get around to it, this week. Pull out every account you have, your retirement accounts, your life insurance policies, your bank accounts, your brokerage accounts. Look at who is listed as the beneficiary. If it says your ex-spouse, if it says a parent who has already passed, if it says your estate instead of a person, you have a problem. And fixing it costs you nothing. It's a phone call, it's a form, it's free. And it could save your family hundreds of thousands of dollars. The third thing almost cost me my own family, and I thank God every day that my attorney caught it before it was too late. When you write a will, or when you set up a trust, you name an executor. That's the person who carries out your wishes after you're gone, pays your debts, files your final taxes, distributes your assets, deals with the court if there's probate involved. Most people pick their oldest child, or their most responsible kid, or whoever lives closest. And that makes sense on the surface. But here's what nobody tells you. Being an executor is a job, a real job. It takes months of work. It requires dealing with banks and courts and government agencies and family members who all think they deserve more than they're getting. And worst of all, the executor is the one who has to say no when someone wants something they're not entitled to. They're the one who has to make the hard calls. And if you pick the wrong person, or worse, if you pick two people and tell them they have to agree on everything, you are setting your family up for a war. I was going to name both my kids as co-executors, Michael and Sarah. Equal say. Sounded fair. Sounded democratic. My attorney looked at me across his desk and said, "Harold, do you want your children to still be speaking to each other after you're gone?" I said, "Of course I do." He said, "Then pick one." He told me that when two executors have to agree on every single decision, and one lives in Pennsylvania and the other lives in North Carolina, and they have different ideas about what's fair, and they're both grieving, and there's money involved, and there's a house involved, and there are memories and emotions and old family dynamics mixed in with all of it. That is when siblings stop being siblings and start being adversaries. And I knew he was right because I lived it with Diane. We couldn't agree on a single thing after Dad died. And there wasn't even a will giving us instructions. We were just two people who loved the same man and couldn't figure out how to share what he left behind. So I named Michael. He's local. He's organized. He's calm under pressure. He's an electrician. He's used to reading plans and following procedures and dealing with inspections and paperwork. That's the kind of mind you need for this. And I sat Sarah down. Not on the phone, in person, at the kitchen table. I told her why. I told her it wasn't about love or trust, it was about logistics and temperament. And she understood. She didn't just accept it, she understood it. Because we had the conversation like adults while I was still here to explain it. And that conversation, that one conversation over coffee at my kitchen table, probably saved my family years of pain. If you have co-executors named in your will right now, I'm not saying it can't work, but I am saying you need to think very hard about whether those two people can actually work together when emotions are high and money is on the table, and you are not there to keep the peace. Talk to your family about it now, not after you're gone. Now, while you can still sit everyone down and explain the why. And the fourth thing, this is the one that breaks my heart the most because it is the easiest one to fix, and the one that almost everybody ignores. A will is not a set-it-and-forget-it document. You make your will, you sign it. The lawyer puts it in a nice folder. You take it home and you put it in a drawer, or a filing cabinet, or a safe deposit box at the bank. And then life goes on. 5 years pass. 10 years pass. You sell the house and buy something smaller. Your grandchildren are born. Your daughter gets married. One of your kids moves across the country. Your financial situation changes completely. And that will sitting in the drawer still says what it said a decade ago. It might reference a house you don't own anymore. It might leave money to someone who has already passed. It might name an executor who is now in poor health themselves. And here is the part that really gets people, and nobody talks about it. If you made your will in one state and then moved to another state, your will might not even be valid anymore, or parts of it might not be enforceable. Every state has different laws on wills and estates and probate. What's perfectly legal in Pennsylvania might not hold up in Florida. What works in Ohio might cause problems in Arizona. And if you retired and moved south like half the people I know, and you never updated your documents to reflect your new state, you might have a will that doesn't do what you think it does. Linda and I review our estate plan every single year, every January. We sit down at the kitchen table with our coffee and we go through everything: the trust, the will, the beneficiary designations, the power of attorney documents, the healthcare directive. We check the names, we check the numbers, we make sure everything still matches our lives as they are right now, not as they were 5 years ago. Not as they were when we first signed those papers. Right now, it takes about an hour. Sometimes we call our attorney with a question. Sometimes we don't need to. But we do it every year without fail. Because I promised myself that what happened with my father would end with me. If your will is more than 3 years old and you have not looked at it since you signed it, I need you to pull it out this week. Read it. Does it still reflect your life? Does it name the right people? Does it account for everything you own today? If the answer is no, call your attorney. Get it updated. It's not expensive. It's a few $100s at most. And it is a whole lot cheaper than the mess your family will deal with if that old document causes problems after you're gone. So there it is. 4 things that most lawyers won't volunteer and that most people over 50 don't know until it's too late. A will does not avoid probate. Your beneficiary designations override everything in your will. Naming the wrong executor or co-executors can tear your family apart. And a will that sits in a drawer for 10 years is a ticking time bomb. I'm not a lawyer. I'm a retired contractor who built houses for 38 years. The only thing I ever knew how to draft was a floor plan. But I learned this stuff because my family paid the price for not knowing it. And I'm sitting here telling you because I wish to God someone had sat my father down and told him. My dad was a good man. He just never made a plan. And every single person in his family paid for it. Don't let that be your story. Talk to an elder law attorney, not a general practice lawyer, not your cousin who passed the bar. Not some website. A real elder law attorney who handles wills and trusts and probate every single day. And then sit your family down at the kitchen table and tell them where your documents are, what your wishes are, and who is in charge if something happens to you. That conversation might be uncomfortable. Your kids might squirm. Your spouse might not want to think about it. But I promise you it is a whole lot less uncomfortable than what happens when you skip it. This is not about money. This is about not leaving a mess for the people you love. I'm Harold, and I'll see you in the next one.